All righty. We are live today, actually tonight, and this is a big one because I usually don't go on prime time. Leave that for the big dogs to do, all the YouTubers of the world. But I am on tonight, and we're going to talk a little bit about what happened today earlier in Orlando, Orange County, Florida. And that case is Jeremy Hales versus Leslie Ferderigos. And we got a few of our friends here. Pebs is here, and Kathy's here already. We have a whole bunch of people watching that just jumped in. It looks good. But we're going to get right into it. We actually acquired from a protected source a full copy of the hearing. And I was actually watching the hearing. I was doing a whole bunch of stuff during the day, but I got a chance to listen to the whole thing. I popped in on the video a few times too to, look and everything else. And it was actually, it was a good hearing. And the judge maybe said 2 words the whole hearing. I think the judge took it all in. I received this as a from a protected source, a picture of the how it looked. And when you went to the hearing, it was a Zoom hearing, and there was Randall Shochet, and he had his background here. I don't know, he's in an auditorium or something. And then you had Leslie Ferderigos, who had a blur. And then you had the judge, and she's the judge from Orange County, Florida. And I'm not going to break the suspense. What she did was she reserved decision. We didn't get a decision from her today. She's actually going to look at all the law and the facts and see what happens next. And we're going to talk about how that's not just yes or no on this motion. There's a lot of different things that happen. And then there were other people, including Piglet. She was looking at the place. So, and it's flying over here. Everybody's saying hello. So who's here? Oh my goodness. I don't want to miss anybody, but I'm going to just put you on the screen. And when you say hello to me, I'll put you on there. Hi, Richard. Hi, Richard. Hi, Richard. Monica. Hi, Donna. Let's see, Grana. Everybody else. G Sky. Hello, everybody. Okay. What I want to do is I want to really get into this because I have the entire audio. It's about a 45-minute long audio, but in order to get to it, I do want to set the stage for what the story is here. And the best way to set the stage is to look at the introduction, and that's in the opposition. That was what Leslie put into the court. So the Shochet puts in on behalf of Jeremy Hales, and for people who don't understand the story or new to it, Jeremy Hales is a serial litigator in Florida. He likes to sue a lot of people, and he does it to create content for himself. He's a media person on YouTube. He started doing like a Storage Wars type show. He wasn't that bad when he started, doing the hidden treasures, and he actually was friendly with some of the people in that storage community. But then after that, he found out in Ohio, maybe about 2020, about 10 years ago, probably was when it all started. But 2020 was when the cases happened, that litigation became a big draw for YouTube, good way to monetize, especially into the lockdown and COVID and all that stuff. This became a very soap opera type thing. So he used litigation and his storage stuff because people weren't going out of the houses. He started suing neighbors, and he had a bad neighbors storyline, and so it's kept on going. And so through this, he's picked up different types of litigation. He sues everybody in sight, and basically it's the cost of his content production. And so, this is what he does. He's suing now Leslie Ferderigos, who is a retired attorney. She was a big time whistleblower attorney, very nice lady. She was working at a school, and he's basically trying to ruin her life. We have a police report where he called and he tried to ruin her life. But I'll put this up on the screen because this is a pretty important thing where we're going to start with this. Now, I don't want to leave anybody in a situation where they don't know what's going on. But this is the paperwork that Leslie Ferderigos responds in opposition to plaintiff's amended motion to declare Leslie Ferderigos a vexatious litigant. So what does vexatious litigant means? That's really something that they put in the law in Florida to make sure that pro se people who don't hire a lawyer, don't come in and just put in crazy stuff. There are some people out there that will put in crazy stuff. And one of those people in particular, Michael Volpe and I have covered, is a guy named Derek Cardello Smith. And that guy basically would put stuff into court that was outlandish, crazy, and he wouldn't serve parties. One of them, he sued Diddy, the P Diddy, who's in jail. He sued Diddy for like $100 million, claiming that Diddy raped him, and then he filed it in the federal court, and he never served him. And then he got a default judgment against Diddy for $100 million, and it was wiped away within a couple of days of it happening because they realized that this guy's crazy. But in order to do a gatekeeper, they do what's called vexatious litigant, and so this is really a gatekeeper. Now, you need to have somebody who's filing things. And remember these words, you're going to hear it a lot: good faith and bad faith. If you're a vexatious litigator, you're filing in bad faith, and that's why the court could punish people. And I'll read I'm going to read like the first 2 pages of this because it gives you the background on what's going to happen. Then we're going to go right into the oral argument because this will set it up. The plaintiffs in this instant case are YouTubers who create YouTube content for profit based on litigation they file against each other. Over the last year, plaintiff Jeremy Hales, represented by Randall Shochet, Esquire, has filed voluminous, frivolous lawsuits dismissed with prejudice against 10 defendants for failure to state a claim. While these dismissed lawsuits are pending, Jeremy Hales and Randall Shocket's knowledge and representation were made harassing contents against judges, opposing counsel, and litigants he was involved in active litigation for entertainment and profit. This content led to mob attacks from reviewers against Judge D. Thomas's opposing counsel in cases, Bruce Matzkin, Esquire, Michael Ferderigos, and among other litigants, Jeremy Hales is suing, including defendant Leslie Ferderigos. On May 19th, Leslie Ferderigos, represented by counsel, Michael Ferderigos, filed a complaint against the plaintiff for defamation, invasion of privacy, and other claims. The lawsuit was filed by serving the plaintiffs with cease and desists. And deceased publishing false and harassing statements about Leslie Ferderigos on their YouTube channels. After the defendant filed the lawsuit against the plaintiff, they increased their harassment, publishing private information about the defendant's life, encouraging their audience in mob attacks and against the defendant and her job and threats, and they published against defendant Leslie Ferderigos. Yeah, that's what happens. It's something in media called brigading. You can look that up. Brigading is actually a real thing. And that's what the term is in social media and in the law and other places. It's a brigade. Hales and his ecosystem are a brigade, and they go and do things all, in concert. A brigade, the best way to think of a brigade is a kitchen, like a restaurant kitchen. You have the head chef, you have an executive chef, and then you have all the different people down on the lines, all the way down to the people that are cutting the celery and the lettuce and the busboys and everything else. But in the kitchen, it's a brigade. There's somebody at the top. And so all these people on the other end of the kitchen that are cutting onions and potatoes, they're following orders. You can go up the brigade, you can go right to the top, and that's the head chef. And they have the sous chef, and you have the executive chef. You have all these other chefs that are up top there. And you have all the line workers and the line cooks and everything else. And that's what you have with the Hales ecosystem. You have one guy on top, Jeremy Hales, and you have his consigliere in Randy Shochet, and you have his, Dr. Goebbels media scumbag, and that's Piglet, and you have all these other people that amplify what he does. And so here we go. That resulted in extreme emotional distress of the defendant, leaving her in a suicidal state. Later, lost the defendant's teaching job as Orange County school teacher. When plaintiff Jeremy Hales contacted defendant Leslie Ferderigos' job as a school teacher, making false statements about her, given the nature of the defendant's employment, resulted in inability to work as a school teacher, to voluminous defamatory content published publicly online. And Jeremy Hales contacting Ferderigos' employment, stating false information about defendant Leslie Ferderigos. Well, I think we have that actually. I'll throw that up. I don't know if anybody. I think some of the other places have shown it, but this is a pretty scumbaggy type thing that he did. He denied it. All up and down that he contacted the school, the Orange County. But here's the sheriff's office. And they made all sorts of incidents here. This is what we have here. This is the harassment incident that we have, and this is coming from Orange County. This is up in Orlando, and so let's see. And this is this is the police report that was made. Okay, and was approached by a blank in reference to telephone for a gentleman identified to her as Jeremy Hales, right? And they have everything here. And so this is the truth. This is a report that was made, and Hales has made contact with people, and anything like that is, if it tells you any differently, he's lying to you. Okay, so she dropped the first lawsuit. That's what this says. And then she voluntarily dismissed it. What do the plaintiffs seek? They declare Leslie a vexatious litigant, silence her from the ability to seek court intervention. Okay. And so that's what we're going to be doing here today. I'm going to, without further ado, I'm going to get to the meat and bones of what we want to do. And it's going to start going. I made a video, so there are some pictures in here for everybody to look at if you want to look at it. So the pictures are pretty fun, actually. They get better and better as we go along. I'm going to start playing the video. I'm going to see what people are saying in the chat, and then I'm going to stop it every so often, and we'll talk about what's going on in the video. It's about a 45-minute video, and Lisa Lee's show starts at about 10 o'clock. So what I'm going to do is I'm going to basically make this thing end about 10 o'clock. So we're going to have enough time to stop it and talk about it, and then everybody can go over to see Lisa's show after this is done. There's a way to do it, and I think she's going to explain that to me. Well, she said she was going to come in and do it anyway, or else we're going to just go there. But this is
just a second. I've let some new people into the room. If you were just recently entered into the room, I need you to mute your device, every single one of you, because it gives feedback. All right, thank you very much. Mr. Shochet?
Okay, thank you, Judge. Ms. Ferderigos, you are a retired attorney, correct?
Correct.
You were admitted to the Florida Bar on April 22nd, 2017. Is that correct?
I would have to look that up.
I'm just going to say, just so everybody knows, the person speaking is the guy up here, Randy Shochet, the pocket rocket. And then that's Leslie Ferderigos. She's the defendant in the case, the retired attorney. And who's not here is a guy named Jeremy Hales. Jeremy Hales is the plaintiff. He's the client of Randy Shochet. This is the judge, a very good judge in Orange County in Orlando, and this is the piglet. So we're going to keep going.
Okay. And you chose to permanently retire from the Florida Bar on March 13, 2023?
Correct.
You're not a regularly retired attorney. Instead, you are an attorney who was approved for permanent retirement. Isn't that true?
I was approved for permanent retirement, correct.
Do you know, as an experienced attorney, that a regularly retired attorney may petition to return to active status, whereas an attorney approved for permanent retirement is barred from ever being reinstated or readmitted to the practice of law in Florida?
Correct. Yes.
All right. And you currently assist your husband's law firm with legal research and drafting?
Not correct.
Okay.
No.
All right. Let's talk about one of the first stalking injunctions.
So Leslie had retired from the practice of law, and her husband, Michael Ferderigos, is a lawyer. And they were trying to, Randy's trying to get him to say that she's actually engaged in the practice of law or practice of law. But Leslie hasn't been practicing law since she retired. So that's a big thing. She wanted to get out of being a lawyer. And she was actually working as a teacher until, as we saw, Jeremy Hales started being a bum juice and calling up on her and having people call up on her. So now Shochet's going to start asking about litigation and vexatious litigation. That's his whole goal here. So listen.
On February 25th, 2021, you filed pro se petition for injunction for protection against stalking against Steve Philadusa, correct?
Correct.
And May 24th, 2021, the court dismissed that petition after a full hearing, correct?
Correct.
And you represented yourself pro se in that case, right?
Correct.
And your request for a permanent injunction, your petition was denied, right?
For permanent, for ex parte, it was granted.
All right, let's talk about another stalking injunction that you filed against someone named Chartine Vieira. On March 3rd, 2021, you filed pro se this petition, correct?
Correct.
Now, as an experienced attorney, you know in Florida, a stalking injunction requires you to state under oath in your petition that you have a reasonable fear of imminent harm. True?
True.
And you voluntarily dismissed that case before a hearing was held, correct?
Correct.
So I'm going to stop here. There's a couple of cases here that we're talking about. Everybody pay attention to this because it's going to be an important theme. There are different types of cases in law. There's a criminal case, obviously, the state brings. But then there's civil cases that are civil matters or non-criminal matters. But all non-criminal matters aren't alike. If somebody owes you money, that's a contract case, right? That's one type of case that you can go. You want justice from the court. You want them to pay me my money. The other is you get into a car accident, you get injured. That person injured me. I want them to pay me restitution. They want to pay me what I'm owed for injuring me. A third type of case you can go to court for is real estate, real property. That's my land. They're the tenant. They haven't paid rent. I want them out. Or that's my land, and I want the boundary settled. That's another type of case. And then the other big case that you're going to get in the state courts are what are called domestic relations cases and family court cases. And you know what? I know a little bit about that. I kind of cover that, me and Mr. Volpe and all of our friends. And there's a few of these types of cases that Shocket's going to talk about that aren't contract cases, A suing B for money, or a personal injury case where you got in a car accident, or even a real estate case where you're looking for rent or something like that. These are domestic relations cases, and they're a little bit different. And there's a good argument they don't fit cleanly under the frivolous litigation statute because, and here's an example. Let's say you're a victim of domestic violence and you have an abuser, right, that comes after you and beats you, and you get up the courage to file a lawsuit, and then they say, well, we're going to get you hit with a vexatious litigant. The court can't, entertain that. The law can't entertain that. The law can't entertain an abuser and be party to the abuse. So obviously you can't say that somebody's a vexatious litigator using it as a sword, right, to try to hurt them. Okay, so keep that in mind as we listen to what's going on.
Claimed you could not serve the respondent in that case, right?
I could not serve the respondent due to, and I admitted this into my evidence, due to her bringing a handgun, and the process server could not get her served.
But you claim you could not serve the respondent, right?
In that case, yeah, there was two cases. I know one of the cases I could not serve her in.
Okay.
I would have to go back and decipher which case. There was a civil case, and then there was an injunction. In one of those cases, I could not get her served.
Okay. Now, if a temporary injunction that you get ex parte, if that's dismissed, it will close the case. True?
Correct.
But here, as an experienced attorney, don't you know that if you can't serve the respondent, then the temporary injunction remains in place, right? Until their service, correct?
Correct.
So, when you voluntarily dismissed this petition, you did so in good faith, right?
Yes, I did.
Meaning that you were safe enough to dismiss the case, you no longer had a reasonable fear of imminent harm, right?
All right, so here's what we're getting into about something like the procedure. And it's very, very boring and technical, but I'll break it down for you in a nutshell, okay? The whole thing about procedure is this. When you have vexatious litigant, and actually Leslie filed something with the court, and maybe I'll put that up real quick so everybody has a reference point so you know what shock it's going to be talking about here. I'll put this up. Hold on, let's show this. This is what she had put up. And let me show you her evidence packet that she put up. And the first thing she talked about was the vexatious litigant law. Okay. And the vexatious litigant law, you need to be a losing party in the case, right? You have a prevailing party and a non-prevailing party. And so you have to see this. An action has to be deemed. See these words? Finally and adversely determined. Okay? Finally and adversely determined. And so when we go back to the video, you're going to have Shockett asking about all sorts of stuff, and Leslie's going to say it wasn't finally and adversely determined because the case was dismissed in a term it's called without prejudice, meaning she had a chance to bring it again. It got dismissed on a technical reason. She couldn't serve anybody with papers, and she couldn't. There was no standing. These are all legal procedure stuff. It's not that she was wrong on the merits. Not that she said something was X, Y, and Z, and it was really A, B, and C. And that's a big difference because you can't be a vexatious litigant under the statute. See, vexatious litigant unless you have a finally and adversely determined. You see that? So keep those words in mind. We'll go back to the video.
Not at that point. No, I did not. That's why I voluntarily dismissed it.
Okay. The threat from Miss Vieira was no longer imminent, even though you hadn't had an company service perfected, right?
Yes, due to situations that happened outside, I no longer felt threatened, and I was not going to waste the court's time with the hearing, so I voluntarily dismissed it, and the court adopted that dismissal.
Right, the order dismissing your petition for permanent injunction was entered, true?
Just adopting my voluntarily dismissal, yes.
Let's talk about another case you filed against Ms. Vieira, a defamation action, and others. You filed it on March 1st, 2021, pro se, correct?
Correct. No, I'm sorry. That was from my law firm on behalf of my business as well, and myself, and there was 3 other attorneys that came into that case, and at the time it was dismissed, there was another attorney on the case as well from the law firm. It wasn't just me.
Let's break it down very carefully, and be careful, you're under oath. You filed this petition, the complaint in that case, pro se, by yourself. You signed the complaint yourself, correct?
It was also on behalf of my law firm because it was a business. Leslie Ann Law was a business, and my law firm, as me as an attorney for that law firm, represented that business. And on top of that, for the plaintiff being a business, it was also on behalf of me as an individual, in which case I represented myself initially.
Right, initially, no other.
So Kathy asked a good question right here, and she says, how can Shochet talk about previous cases that were decided that have nothing to do with him? And I just want to be very clear, that's the nature of what vexatious litigant is. What they're trying to do is they're trying to do a gatekeeper on the docket, saying that Leslie can't file anywhere in the state of Florida. She needs a gatekeeper motion before she can file anything, before the court will take something for filing. And you can talk about other cases that fit that bill, but they have to be, finally and adversely resolved. And what we're going to be hearing here is these are cases that are not finally and adversely resolved. These are cases that are, either were dismissed without prejudice, or it's some type of procedural reason. It wasn't a final adverse adjudication on the merits. So we'll hear some more.
Lawyers were involved when that complaint was made, right?
Initially, they became involved after.
Okay. And you were involved in that litigation from March 2021 through October 2022, right?
If that's the dates, I don't have them in front of me, so I would assume so.
That case involved extensive litigation activity, including discovery requests for admissions, motions to compel, and multiple hearings, correct?
There was only one hearing.
And there was a voluntary dismissal entered in that case that you and only you signed, correct?
Well, Andrew Probst was co-counsel, and he was still on the case as co-counsel. So when I voluntarily dismissed it, I signed my name as Leslie Ann Law, and he was still counsel of record as well as co-counsel. So I was not the only person on that case. He had never withdrawn from the case at that point.
You were the only one that signed the dismissal, correct?
Correct,
but there was another attorney on the case as well.
That's an important distinction because under that statute that we just saw, the vexatious litigant statute, you need to be a pro se litigant. And if you had a lawyer at any point in the case, even if the lawyer drops you to become a pro se at the towards the middle or the end of the case, that still doesn't count because the case was brought with a lawyer. So there were lawyers involved on the case. So he's talking about cases already that already don't fit the statute. Everything that he's talked about so far is not a clean civil case, and it's not one where Leslie's a clean pro se party. He's got to get like a bunch of these cases, got like 5 of them to show that she's vexatious, to show a pattern. And he's really not getting anywhere with the question. So keep listening to his line of questioning.
All right. And given that you dismissed this case in October 2022 and more than 2 years now have elapsed, you cannot refile that action now, correct?
There was other claims. I would have to look at the statute of limitations to see, but I don't intend to refile it as I don't want to move forward with that case. There was a lot to that case.
All right, let's talk about another defamation action. On December 20th, 2023, you filed pro se a complaint for libel and slander against Kayla Ferderigos, Paul Russo, Nicholas Ferderigos, Kathleen Bors, Danny Ferderigos, and Eleni Ferderigos, correct?
Correct.
And And some of these people are related to you, correct?
Correct.
Including Kathleen Boers as your mother, correct?
Correct.
All right. The court dismissed that case on August 22nd, 2024. Isn't that true?
They dismissed it without prejudice for failure to timely be able to serve within 120 days. After that, my husband, who is an attorney, mediated with his family members, and we decided to not pursue it after the court dismissed it without prejudice, leaving it open for me to file again should I want, but it was mediated.
That's Randy Shochet, everybody, in case you don't know. Randall, the Pocket Rocket Shochet.
And settled with a family member, so we did not pursue. I did not move forward with refiling.
Right. The reason why the court dismissed the case that you filed pro se was because you had not perfected service on the defendants within 120 days of filing, right?
I couldn't get all of them served, no.
All right, let's talk about a 2024 domestic violence injunction case. You mentioned Michael Ferderigos, and who was your husband.
Hello?
And your lawyer in some cases, right?
Correct.
Hey.
On July 23rd, 2024,
Okay, well, I'm watching a
you
court
filed pro
hearing.
se a petition for injunction for protection against
I'm
domestic
watching-
violence. Dismissed that case before a hearing again, right?
I settled with my husband, who agreed to go to treatment. We signed, he is in the, if you actually had the documents to the cases, not just the titles, you would have seen, I dismissed the case after he agreed to attend treatment.
Okay, so the court entered an order dismissing the injunction after a hearing on August 1st, 2024, right?
There was never a hearing.
So remember what I said before about domestic relations? Okay. They're trying to use domestic relation cases, family law cases, domestic violence potential cases as vexatious litigation. And I guarantee you, we go to the Florida legislature, and there's a lot of the stuff that Leslie put into the court about this, is you don't go to any of the legislators and they're going to say, oh, we want to hurt domestic violence victims. Okay. And so that's the point here. This is a situation where Leslie had filed a couple of domestic petitions, and both of them actually ended up being resolved favorably to Leslie and to Michael. The first one, I think that he went for medical treatment, and they're doing great after that. And the second one you're going to hear is they withdrew the petition in court and decided to go to church. They went to church together, and they resolved it in a religious forum as opposed to a public judicial forum, which is their right, and they have a First Amendment right to that too. And the court can't really, look into that. So we're going to hear that in a second. But keep that stuff in mind as you hear what Shochet is prying at.
There was never a hearing in that case. It got granted ex parte. Prior to going to a hearing, my husband and I worked this out where he promised to attend treatment. That was when I voluntarily dismissed the case. We never had a hearing on that case, and the court adopted the voluntary dismissal.
Right, so you didn't want to maintain the protection because you said you had a reasonable fear of imminent harm simply because he agreed to go to therapy. Is that what you're saying?
He agreed to do a therapy program, and we were not living together at that time.
Okay. So a year later, on March 3rd, 2025, you filed another pro se petition for injunction for protection against domestic violence against Michael Ferderigos, right?
Correct.
And the same thing applies. You swore under penalty of perjury that you had a reasonable fear of imminent harm again, right?
Now, this is the second domestic that he brings into this. And this is the one that we talked about with the church. Before we get to that part, I want to bring up a comment here. Actually, where is it? This is it right here. Melissa says, is it legal for you to air this? And I did not make the recording of the Florida proceeding. I'm a member of the press. I received it from a protected source, a recording, and I'm airing it. It's well within my rights to do. I'm not doing anything that's in violation of the law. I actually was on this call before on the actual hearing, and I obviously didn't engage in the recording. This is I have every right to broadcast this as a member of the press. So just we'll get that issue out of the way almost immediately. There's no problem with me showing the people what's happening in their government. So let's continue.
Correct.
Yet, next day, you voluntarily dismissed the case, right?
I did.
And you stated in your response to request for admissions in this case that temporary order was granted but settled prior to a permanent injunction, right?
Correct.
All right. Can you tell the court in that case how you can settle a case like that when the very day before you swore under oath, under penalty of perjury, that you were in fear of imminent harm?
Because we decided to go to a church. And we thought we do not like the court. We do not like being wrapped up in court. Ironically, as you were trying to say, I'd like to flee away from the court. It was a family matter, and we decided to take it up in church. We thought that was the better route. We had an extensive discussion, and I voluntarily dismissed it.
Okay. I just want to make sure to get this clear. So within a year, you filed pro se 2 domestic violence injunction petitions against your husband, obtained temporary orders, and then voluntarily dismissed both cases before any permanent relief was granted, right?
Before any hearing or permanent relief, correct.
All right. Let's 2 more cases to talk about here. Let's talk about the guardianship appeal for the second DCA. You were the attorney of record in this guardianship matter in which you represented the mother of a ward, correct?
Correct.
And you, as the attorney, received sanctions in that case, correct?
My client and I both did, correct.
Both you and your client were sanctioned, right?
Correct.
And you filed pro se an appeal to the Second District Court of Appeal.
I did.
As the appellant pro se, right?
I appealed the sanctions against me personally as the attorney on the case.
And the second that were case number 2D23-424, correct?
It was a 2019 case. The state case, the guardianship case, was filed in 2019 by the ward's mother. I came on to the case later. I represented the ward. It was a discovery issue that we got sanctioned on, and I chose to appeal because at that time I ended up leaving the case. I was no longer representing the mother anymore, but the sanctions were still against me as well as her. So I represented myself in appealing the decision against me.
Right, but the appeal had a 2023 case number, right?
But it was attached. The whole case started in 2019.
The appeal didn't start.
It was.
This is Leslie right here, so everybody knows that's Leslie, and that is the germ, Mr. Palomop himself, just so everybody's clear on who the cast of characters are.
The appeal was 2023, but the case that it stemmed from was 2019.
Thank you. And the second, you lost that appeal, right? The Second District Court.
I did lose that appeal. Yes, I did.
All right. And that appellate decision was a final and adverse determination against you. Isn't that true?
Correct.
All right. Let's talk about.
Now, that's an important thing. Everybody keep that in mind because there's a final appellate determination, but appeals start as regular cases in the trial court, and it's only one case. If you lose the case in court and you go to the appeal, it's not 2 cases, it's only one. And in order for the case to count, they amended the statute. And and Leslie's actually going to do an excellent job talking about that on this stream. They amended the statute. You can't use cases that started before the statute was amended, right? So that's something to keep in mind too. So even if she did lose an appeal, Leslie's argument, and I think she's right on it, is that unless the case was started after the amendment, which was only a couple of years ago, the case doesn't count for vexatious litigation. So everybody keep listening.
The federal case you filed on February 2nd, 2023. You filed pro se a civil action in the United States District Court for the Middle District of Florida against the Florida bar, correct?
Correct.
You were the plaintiff in that, correct?
Yes, I was.
You represented yourself in that case, correct?
I did.
And in that case, you filed pro se
an
an original complaint.
She's lovely.
Then
Active lawyer.
So this case is an important case because it's a federal case, and the federal case is not a Florida case. Even though it was in the Florida federal court, the Florida system and the federal system are 2 different systems. So the Florida statutes don't apply to the federal courts, directly. So that case is outside of the purview of the statute palpably, number one. Number two, the second thing is, and we're going to hear it in a second, the case was dismissed on a technicality. Leslie brought the case against the Florida bar when she was a lawyer. She decided to retire, right? And by retiring, she doesn't have a membership in the Florida bar anymore as an active member. So the case became moot. Or so she got, it was a lack of standing, dismissed for lack of standing. That is not a final and adverse determination. That's a procedural. Listen.
And so however that went, I don't know. I would have to look at the case before I can answer those questions with definitive answers for you. But I can tell you that was the initial reason that case got dismissed, was for lack of standing when my status changed.
So I want to make sure we get an answer here. You'd have to see the docket sheet to be able to answer the question that you filed pro se, all within the opening days of the case, an original complaint, then an amended complaint, then a motion to amend after you filed the amended complaint, and then a second amended complaint. You would need to see the docket from the federal court.
Yeah, I'm sure if I did, it happened in the beginning. However I amended, I exercised my right to be able to amend, just like any attorney would in cases. They have to amend things when newly discovered evidence happens, things like that. It gets amended, and that's more than likely why I amended it. But regardless, the case was dismissed because of my status changing.
Right. The federal court issued a report and recommendation recommending dismissal of your second amended complaint for lack of subject matter jurisdiction on mootness grounds, right?
It was moot when I retired my license.
Right.
That was what you'd have to read the whole order, but that was, from what I recall, that was the big reason, was because my status during litigation had changed from an active attorney to a retired attorney. Therefore, it was moot and it was no longer an issue.
Well, that's interesting, because after the case was closed as being moot, you filed pro se motions to vacate, motion to disqualify the magistrate judge, and motions for reconsideration, correct?
Correct.
And all of those,
the magistrate,
all of those post-dismissal motions were denied, correct?
correct. Yeah.
The case terminated August 21st, 2023, right?
It did, but everything I did was in good faith, and there's always legal grounds to everything. Should you be inclined to give the court the actual filings and not just the titles in a docket, there's nothing that I have ever filed that has not been backed up by law. No court in any of these cases have ever found me to be frivolous, bad faith litigation. I have never been found to do duplicative filings on things that have already been decided. Anything I did, it would be no different than I was exercising my rights under good faith.
Oh, so that is one of the commentators, Piglet. She was actually on the live, I think, or on the thing. But Piglet is there, and so what Leslie just said, I stopped it there not because Piglet came on the screen and scared me because she's hideous, but what happened was she said something very, very important. She said that there were motions filed, there were cases filed, they were all filed in good faith. Nothing was filed in bad faith. Everything had merit, and most importantly, all the judges said so. None of the judges went out of their way and made a ruling that she filed something in bad faith. She filed something without merit. She filed something that was not in good faith. She filed something that was harassing, inflammatory. They made none of those findings. Okay, so that's an important note to have. That she got that in the record. That's part of the record now and the testimony. Nothing was not meritorious. Nothing was in bad faith. And there were probably 4, 5, 6, 7, how many Florida judges who made the record that if this judge were to overrule, they would be overruling those 7 judges. So that makes me think, I don't think this judge is going to find vexatious litigant because no other judge has found one. No judge has found bad faith. No judge has found any of the elements to it. So let's keep on going here. And everybody, Piglet has joined us.
All right. Let's looking at your litigation history. You have fought at least 8 separate actions between 2019 and 2025, correct?
Correct.
All right.
Well, I would say 2019. No, that was when the one case started. But yes, there was 8. There was, it's in my response, 4 injunctions, 3 civil cases and the appeal from the guardianship case. Now, you never mentioned in your amended motion about the federal lawsuit, so I never knew that that was coming in until just now, because that was never pled in your amended complaint that's before this court today.
All right, let the record reflect that it was in my memorandum reply. So in all of these 8 cases, you obtained absolutely no permanent relief or favorable final judgment, right?
Get this fucker.
I never had on the merits of any
There's
of my complaints.
Eight cases, right? He said, they're saying that there's 8 cases, right? That's the number he's saying. And we've already showed that one of the cases is a federal case. That doesn't count. We have a couple of the cases that got dismissed without prejudice, meaning that they're not on the merits, right? We have several cases that are domestic relations cases where, the court would be saying, to hold it against somebody, was saying that battered women have no rights, and battered women shouldn't go to the courthouse because they could become vexatious litigators. As victims of abuse can be punished for using the court system. That doesn't happen. So he's got 8 cases. I don't think maybe he's got an argument on 1 or 2. That doesn't get you vexatious. I didn't even make a pattern. And Leslie says she was in good faith on every one of them. There's only a question on 1 or 2. I think the other 6 are dead on arrival. So he's not even close at this point. Not even close.
For the one injunction case, that was it.
Let's try one more time. I didn't hear an answer. So in all 8 cases, you obtained absolutely no permanent relief or no favorable final judgment, correct? Yes or no? It's not really a yes or no, because there was no adversarial determination except for one. I could have easily, if I wanted to go back and I wanted to refile the civil case that was dismissed for lack of service, I could have done so. So I wouldn't consider that as, I couldn't, that it was a permanent stop for me to do anything. I chose not to. But at no point did I ever have anything dismissed with prejudice, or have a court tell me that I lack merit in anything that I've ever filed. I've never been told that I was frivolous. I've never been deemed to be bad faith. I've never had any court, that was under the jurisdiction of these cases, ever find me in any of those capacities. So if I wanted to refile something, I could. I was never stopped from that. I was never limited. So I can only have a couple minutes left.
Go, Leslie. Go, Leslie.
Okay. So Tim has a good question. Why can't these judges see that Jerm and his orthodontic lawyer are full of shit? And these judges throw these motherfuckers under the jail. Well, it's getting there. Mike Volpe did some good investigative journalism, and he put out an article last week about how this has been a huge thing that he's been doing for years. It looks like a decade that he's been doing this litigation as content shtick, the Palomop. And there's a lot of lies if you go back there. If you go back there, George, who disappeared, aka Martha, said that she was a contractor in one of the affidavits, one of the Palomop affidavits in Ohio. Not that they were in a relationship, that she was a contractor. They had a business relationship. And, so maybe we can start to get to them, maybe we're going to start catching their own lies. Maybe as we go back to the older stuff, we'll figure out what we got. But let's play some more.
So you, as a former attorney, you are familiar with Florida's vexatious litigation law, correct?
Well, the actions that have taken place when I was on notice was the original vexatious litigation law 68.093. It only got amended in July after the actions that I took part in. So I was very familiar with the original during the times of those actions. But no, I would have never anticipated having to, I was never placed on notice that injunctions for my protection would deem me a vexatious litigant when I chose to file those. So I was operating under the original when every single action I've ever filed was under the original statute that I was noticed on.
All right. And you are aware that the 2025 amendment expanded the definition of action, quote unquote, to include now family law matters, right?
I'm aware that it's very substantively changed, and it has not only expanded what is called an action, but it's also expanded the look back time. It's also given more sanctions available to a court. It has also changed the definition of what pro se means during litigation or during an action. So it has greatly substantially changed, the new amended one. But when my actions took place, that it wasn't in effect. I was under notice of the original statute.
All right, you understand that.
That's a huge point here, that she's going to be judged under the statute that was in effect. And yes, the law got changed to include certain family law matters. I still think that they can't include, and it hasn't been up to the Florida Supreme Court yet, domestic violence type stuff. I don't think that would be a possibility. It's almost like you are stopping people from reporting crimes. Like you can't stop somebody. You can't file a law that says people can't report crimes. Then we have anarchy. Well, you have a smaller subset of anarchy with abusers. So that's another issue that has to be litigated with the Supreme Court of Florida. And what are the contours of family law cases and domestic relations type situations? But she's 100% right, Leslie. And Mindy says it right. Listen how calm, professional, and precise Leslie is when she talks. She really, really is. She's on point. It gets better. Wait.
Filing a lawsuit with the intention of withdrawing it before prosecution in order to create a public record does not constitute filing in good faith, right?
I would say what you showed the court is not complete, and it is not authenticated. It is not dated. So to operate under the fact that those were my words outside of court would be, it wasn't even authenticated, dated, or it doesn't even explain to what I'm even talking about. It wasn't complete as well. But no, yes, of course, when you file, everything gets put on the record, but that's not the only reason you file. I filed everything I did with good faith. I have affidavits that in the one of the lawsuits that you had mentioned, I have affidavits from 3 different people that were filed as well with that complaint. I don't file frivolous complaints where I don't have evidence before I file those. So no, I don't just file things to be put on the record. It's a given they'll be on the record, but that's not the motivation of why I have filed my lawsuits.
See, again, there's no answer here, but this is important. You understand that filing a lawsuit with the intention of withdrawing it before prosecution in order to create a public record, that does not constitute filing in good faith, correct?
I wouldn't know that because that's not anything I did, and I don't know. I know what good faith is. I know the definition of good faith, and I'm prepared to bring forth evidence that everything I did was filed in good faith. And if you gave the judge the opportunity.
And so I'm going to show some video of what's called bad faith. If you have a queasy stomach, you may want to get the barf bag ready.
To read through all the pleadings of every one of my cases, not just the titles, you could see very clearly I never filed anything that was not in good faith and was not supported by the law, nor has any court who had jurisdiction over those cases ever found such.
All right, 2 more questions, then I'm going to turn it over to Ms. Ferderigos, Your Honor. Ms. Ferderigos, you understand that if you are declared a vexatious litigant, you may be required to obtain leave of court before filing new pro se actions. Do you know that?
I have seen that now. Yes, I've seen all of the new sanctions that they have now broadened the statute. I've read it extensively. I've also read the discussion with the House on this bill. I'm very familiar with this bill, and I'm very familiar with the substantive changes that have taken place with the amendment.
All right, if you're very familiar then you obviously understand that you may be required to post security to cover the opposing party's litigation expenses, right?
Security would be if I actually filed this lawsuit against you. You filed this lawsuit against me. And for the judge to determine whether or not I needed to post security, would not only the judge would have to find me vexatious under my past actions that the different statute was operating under, when there's been no final and adverse ruling from a court, but the judge would also have to look at my filing against you, should I file against you of the lawsuit, and they would have to determine whether or not I would succeed on those grounds. It is not right to ask for a security when I'm the defendant in this case, and I have not filed a lawsuit against you at this date.
You do know that the 2025 amendment changed that to make
that was very good, right?
Post security covers an opposing party's litigation expenses, whether or not they're a plaintiff or a defendant. Have you understood that? The 2025.
I've read.
Again,
I've read the. No, I have not understood it like that. I've understood it that a security is there should I file something on you, and the court would have to determine whether I had merits because you have sued me. I am a defendant not wanting to be involved in this, and I'm unemployed. because your client called my school and defamed me to my school, losing my teaching job over this, which we have a police report. We can talk about it at a later date. But no, I am not. I am not.
Good job,
employed
Leslie.
right now.
She got that.
So this is one of the things we need to address is that Shochet is being not a very, very good lawyer here. And what Shochet is doing is when you are cross-examining somebody, especially somebody who's halfway intelligent, okay, you need to make sure that you don't ask a question you don't know the answer to. And you can't let the person start talking. You want to ask yes and no questions, right? You want to keep it very, very tight. And that's not what this guy did. This guy let Leslie start getting in all the stuff about how bad Jerm is. And that is very, very, very bad. It's actually poor lawyering on Mr. Shochet's part. So we'll watch some more.
Get in there. Woo, woo.
Exhibits 1, 2.
And I object on hearsay. I object on the rule of completeness. I object on best evidence rule and relevance because, again, my actions, and I have case law to provide this court. Am I able to start, Your Honor? I apologize. Am I able to start my...
Your objections are overruled, so go on and begin your presentation.
Thank you, Judge.
Yes, Your Honor. Okay, so the plaintiff has cited 3 civil cases, 4 injunction cases, 1 guardianship case, and a federal case that was never noticed in his amended complaint, although he says was in his memorandum, but a memorandum is not meant to amend an actual motion before this court. So I was not notified to that until today that he intended to argue that. And I would have an issue with due process on that. First of all, I have done absolutely nothing that was not in good faith. Everything I have done, no court who had jurisdiction to those cases ever found me.
So what Leslie's doing here is she's raising in the record all of the legal issues here. And the big legal issue is the insufficiency of the claims that Shochet's even made, that Jeremy's even made against her for claims of being vexatious litigation, and saying that they need to do a full record, right? A full record to try to figure out what's going on here. They got to, and that's not what they've done. They did a half hour each. They did some limited briefing, and her argument is that there isn't enough here for the court to even determine anything. The court should just dismiss this, or if the court wants to do something, then the court has to, bring everybody back for a more substantive hearing, right? And so at this point after this is when she starts arguing the law, it starts to come up. So this is when it gets really, really fun. And we're going to have some more pictures too. This is not the only video we have.
Not have done something in good faith. Those are the courts in good faith. This court would have to go back through every one of those cases, read every one of those pleadings to decide whether or not they were made in good faith, not just reading titles in a docket. Again, there was no adverse and final decisions. There was one in an injunction case, and the reason that was not granted permanently was because of the attorney-client relationship. That's what the court had stated. If you actually had these orders in your hand, you would see that there was nothing, no court order ever saying that my case was dismissed with prejudice or that my case had no merit. The only court orders were the ones either adopting my voluntary dismissals or saying that I needed, that I didn't perfect the service in time. But anyways, I'm going to go ahead and go on. Under Menendez versus Progressive Express Insurance Co., the 2010 case, the central focus of the Florida Supreme Court's inquiry into whether a statute applies retroactively, which is essentially what Mr. Shochet is trying to do, is whether that retroactive application of statute attached a new legal consequence to events completed before its enactment. There are definitely new legal consequences for events completed before the enactment of this amended statute. It looks at the facts under the original statute. This case on its hands would be dismissed today because there was not 5 civil cases that met the criteria under the original statute that I was on notice of when I filed my cases. Today, plaintiffs are attempting to have this court sanction me under a new amended statute as a vexatious litigant, which would entail new legal consequences on any lawsuit that I ever filed prior to the amended statute, when these lawsuits, again, were never found by any court who had jurisdiction to find such. Find me ever vexatious or frivolous, or anything finally adversely determined. It is clear that the issue of a retroactive application of the amended statute needs to be addressed. prior to
This is what I was saying before. Retroactive application of the statute, right? We talked about that. Application of the statute and retroactive application of the statute. That's very, very important because you cannot hold somebody accountable for the new statute when they did stuff under the old statute. Think about it. You just can't do that. It's a due process issue. And that's one of the big issues he has here. I'm gonna come back. We're gonna come back to this, but I want to show this because she did such a good job with the this little packet because it shows. Look, this is the first statute here, right? Effective October 1st, 2000 to June 30th, 25, vexatious litigant law. And that's the law that she has to be judged under because that's the law that was in effect really for most of the cases, the 8 cases that Randy said. And remember the words we said that anybody came in a little bit late and missed it, finally and adversely determined. That's our standard. The case has to be finally and adversely determined against Leslie. And we heard from all of those cases, I think maybe 1 or 2 could even potentially get to that standard, finally and adversely determined, because they were statutes or they were cases that were not resolved on their merits. It wasn't, they didn't find out who was right. It was because of standing or mootness or somebody didn't get served. They're all procedural reasons. The other part is that, as Shochet said, there are family law issues here, and the court didn't amend to include family law until afterwards, and that's the second statute we have here, right? The vexatious litigant law, effective July 1st, 2025, right? So that is only stuff from 2025 on covered under this law, and the situation, he put in some family court cases, but the Supreme Court of Florida hasn't ruled on this whole law yet. They haven't ruled on the full contours. This law might not be a valid law in full. There might be parts that are unconstitutional. And the family law section might be the part that's the issue, because you're encouraging domestics in the sense that you're encouraging non-reported domestic incidents for the fear of for fear of being tagged a vexatious litigant, but fear of punishment. So she did a good job putting this to the court. The court has all in front of her. And then there's all these cases we're going to hear right now. Campus Communications versus Earnhardt. She has about 5 or 6 more. I think Morales is one of them, or forget the name of the case. But these are long cases that are in here. The whole packet is in here, and people can look through that. But I don't think we need to do that now. So we'll go back to the hearing and check it out. Let's go back to the hearing.
Evidence to satisfy the new amended statute when I argued these events took place during the original statute. Retroactive application requires a 2-pronged test. When there's 2 Florida Supreme Court cases, Florida Insurance Guardian Associate Inc., the Devon Neighborhood Association, a 2011 Florida Supreme Court case, Menendez v. Progressive Express Insurance Co., which I've already cited. They made clear to retroactively apply an amended statute, which is essentially what is being done here. There's a 2-pronged test. The first is that the court must ascertain whether the legislature intended for the statute to apply retroactively. There must be clear language. The 5th District, in the 5th District of Florida, the case law Campus Communications Inc. v. Earnhardt specifically states that legislative intent must be determined primarily from the language of the statute. It must be clear and unambiguous. It must be clear and definite. They go on to show an example in the instant case. The legislature was clear in its intent because they twice expressly stated in the amended statute that it was to be applied retroactively in that clear language. And the new amended statute, no such language exists. So for that alone, the first prong fails. And if one of those prongs fail, you cannot apply retroactively. The second prong is...
See, retroactive is not available. She already showed by the first prong is no good. Now she's going to go to the second prong and say, well, he's dead twice. Watch. This is pretty good.
If the intent is clearly expressed, the court must determine whether retroactive application would violate constitutional principles. Mr. Shochet tried to lead this court to think that this amended statute was just remedial or procedural. However, that is not such. Even in the case law that he has provided to this court, makes clear exactly what is substantive versus what is remedial and procedural. On prong 2. So it fails because the amended statute is substantive, and it's substantive if it affects a vested right, which I had a vested right at that time to file those lawsuits without the fear, especially the injunctions when I was going for my protection, that would work against me and deem me a vexatious litigant, or if it creates a new obligation or imposes a new penalty. Well, it clearly creates new obligations, and it clearly...
Oh, I just need to let everybody know, this is the piglet breadsticks portion of the program. So if you have an aversion to piglets and breadsticks or the combination of the two, you may want to leave the room.
Imposes more penalties, and I can show you the exact language in the statute that brings it to such. It's under Menendez, again, progressive express insurance code. But moving on, examples of cases that have been found that Mr. Shochet cites in his own amended, his memorandum of law. These are cases that were not allowed to be applied retroactively. In Young v. Altanas and in Matthews v. Pullman, a statutory requirement that the non-prevailing party pay attorney fees is a substantive change. Retroactive application to actions that occurred before that amended statute cannot happen. It would be deemed unconstitutional. Another example in Gupton v. Village Key in the Saw Shop Inc., an employer's effort to enforce a non-compete agreement after a statutory amendment changed the governing law constituted a substantive change affecting a vested right. Under Carmel v. Texas, a 2000 case, the Supreme Court in that case held that a statute permitting conviction of sexual offenses based solely on the victim's testimony when previously corroboration was required constituted a substantive change. Such an amendment which reduces the quantum of evidence required for a conviction, which clearly in this case, the evidence, it opens the door to be taking in family law cases that I could have never anticipated would ever be used against me.
So I got two pieces of commentary. One, Leslie knows what she's talking about on the law. And number two, I think Megan's eaten about 10 pounds of breadsticks already. I wonder how many she gets to by the time the thing is done. Let's see.
At those times. In Carmel, the changing evidentiary requirements for treason. This was, Carmel, Texas. It was also cited in the Fenrick case. Changing evidentiary requirements for treason convictions after the alleged crime occurred. That law's reduction of evidence required for conviction was held 13 to be substantive and not allowed to be applied retroactively. On docket number 75, which I have also submitted to this court in a judicial notice of the Florida House of Representatives final bill analysis, comparing the wording using both versions of 68.093, both the original that I was operating under and the amended version changes in the following ways. It increases the range of cases that can be applied, now applying family law cases. It redefines how a pro se litigant is determined. It expands the lookback period. It allows state and federal cases to be assessed. It allows the court to impose security against vexatious litigants regardless if they're a plaintiff in the case. It broadens the sanctions available against vexatious litigants. Once determined a vexatious litigant, a court can now deny their request for relief, strike their pleadings, render a judgment by default against them. Further, the amended statute clearly says if a litigant in good faith filed what they filed, they cannot be deemed vexatious litigant. So the court would have to go through all of my cases when no other court that had jurisdiction to do so ever found these to be bad faith. And this court would have to determine whether or not my filings in my cases were done in good faith. That would require me to present testimony and give evidence. And one of the reasons why I said 30 minutes was not enough if the court did not determine which statute is going to apply. Thus, similar to these cases cited, this is a substantive change. The amount of evidence to determine when vexatious is changed, allowing more sanctions to be imposed on past actions under the original statute, using actions where the defendant's vested right to litigation in these cases at that time, I had that vested rights, not feared that was going to be used against me, would have never placed me on notice in any of these cases that I would be up for sanctions as a vexatious litigant when I filed such. The defendant has vested interest and rights when I filed my 4 injunction cases for my protection without believing that somehow this would end me up as a vexatious litigant. The amended statute creates new legal consequences to.
This is an important point. The important point is that how could she know that the statute was going to be amended to create a greater coverage of cases and greater penalties and greater X, Y, and Z in 2025? They can't use any of the situation from before to 2025 on for the new law. If it's the new law, right, then it doesn't apply anymore. Okay, the stuff that they're talking about, because the stuff that it only applies from 2025 and after. So it doesn't apply for the period before. So how can you hold her accountable for that? So, of the cases he's bringing, I think almost every one of them might be before the period that should be involved. So that's an issue, a huge issue as well.
And it impairs vested rights, creates new obligations, and imposes new penalties. Remedial, in Mr. Shochet's own memorandum of law, what it means to be remedial is defined in State v. Kelly. Means for enforcing existing rights does not disturb substantive rights or imposes new liabilities. Statutes granting the state a right to appeal a judgment of acquittal, that would be remedial. Emphasizing the right of an appeal is remedial. A new procedural bar, according to Tradaha, for the forfeiture, that would be remedial. The Florida Supreme Court in this, the city of Orlando v. DeJarens says statutory exemptions for attorney-client privilege, that would be remedial. Village of El Porto v. City of Miami Shore states deadlines would be remedial changes. None of that are what is applying today with the attempt to get me deemed a vexatious litigant on a newly amended statute for past actions that occurred when the original statute was into play. Plaintiff's argument still.
Okay, so this is a very good question. Jeremy claimed today the judge stated which statute will be considered. Is that true? No, that is not true. It was actually, the judge's reserving decision. So that means that the judge could go back and decide the facts in the law as the judge sees fit. So we don't know exactly what's going to happen because the judge reserved the decision. We're going to hear that in a couple of minutes at the end of this when the judge speaks. So that's what we're going to get to next. Also, if Lisa's on here, Lisa, I'm going to try and get everybody over to your show when this is all over. I know we got to knock it in. I think your show might be members only, but I think it's not a members only show. Obviously, everybody's on for Lisa Lee, 2 Lees at 10 o'clock. But I don't know if you have to change anything on the back end on YouTube so I can do that. If you can do that, if I'm doing it wrong, you let me know. But I'm going to try and get everybody over to Lisa's show when this show is over. Let's see if we have it here. Yeah, I don't see you up here yet. I'm on the back end, Lisa, and you're not up. But get it done, and I'll try to get everybody over. If not, after I'm done, stay on and watch Lisa Lee and Robbie and the whole gang on that stuff. So let's watch some more. And we're not going to see any more breadsticks. It's almost done with the breadsticks. It's really, really sickening, isn't she? She's a sickening beast. Look at that beast. She's a sickening, sickening beast, eating all the breadsticks that day. Like she must have eaten about 50 pounds of breadsticks as we're watching this. She's just disgusting person on the inside and the out, mostly on the inside. That's a disgusting, disgusting thing. And so, and I see that we have a lot of people in the chat. The chat's flying by today. I know that there are people that are being salty. Be nice, please. That's all I'm asking for. So we'll see. Richard, what is this? Richard, do you know what that pig needs, don't you? I don't know what that pig needs. What is she's a pig. She needs breadsticks, I guess, right? Breadsticks. All right, let's watch some more.
Fails under the application of the amended statute. So if this court even were to go to the amended statute and apply that statute, it would still fail. It would fail for the following reasons. There was not 5 cases that were finally and adversely determined. The defendant I had representation in 2 of those civil cases. In my response, I gave tables to make it very easy for this court to look at the cases to see exactly whether the criteria was met. And all of these cases were filed in good faith, where no court who had jurisdiction at that time ever found them to be frivolous, meritless, or in bad faith. For this court now to go back through my unrelated cases under different jurisdictions of outside courts would be not only improper, it would require a full evidentiary hearing for my due process rights to be able to present evidence and testimony to prove that every one of my.
So that's the most important thing right there. You have determinations in all these cases by all these different judges, right? And they're not clearly in the opinion saying that she committed bad faith, that she was vexatious, that she was frivolous, right? And so the situation that we have, right? The situation we have is that they would have to do a full case and a full evidentiary hearing and do what they have to do, right? They'd have to do a full, almost like a full trial, like a mini trial, and hold call witnesses and everything else. And the judge has to make a determination. And let me tell you, the judges don't usually overrule other judges. When you have 5 or 6 or 7 that said there's no bad faith, they're not going to overrule those judges. Now, on the converse, or the opposite, if you had 5 or 6 judges that said Leslie Ferderigos was acting in bad faith in filing cases, then maybe that would be a finding and it would be an easy finding, but there's no finding there. And so this judge, I don't think, is going to rule that way. And even if the judge does rule that way, which I don't think they're gonna, then this is not going to stand up in the District Court of Appeal. This will be, thrown out pretty quickly, or sent back down. But I don't think this is. I think this is a dead issue. Listen to this hearing. I think that we saw it today. I think that the paper tiger is a lot different than the when you hear what's going on, right? Jeremy comes on, or Tug, or the Piglet, or a Shizzy No Nuts, or Mr. Kook, or any of those people. They all turn around and they read like dramatic reading of blah 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 blah, and it sounds like Jeremy actually has a story, right? And he has a case. It sounds like he has an argument. But then when you get to court, you hear Randy Shochet fumbling along, and you hear somebody like Leslie dismantling him. Everybody knows what time it is. That's what I think the biggest problem with Fed 2 was, and it still is. The court hasn't seen what's going on. It took them 2 years to dismiss everybody in the first tranche in Fed 2. And I'm telling the court, play the video, play the Megan Fox, alleged, what's the name? Jeremy Hales sex with a journalist tape. Let's see if that's a revenge porn. They do the same thing with this, in this case, that they do with the revenge porn. They pick 2 statutes. It got amended. They're using the wrong statute, but that's what they do. They put it on paper and they play, high school gay drama club, and they read it out loud, and people think that they got stuff going on, but they don't. Did the judge make a decision? No, not yet. They reserved this year. When they go back, we'll hear it. I'm gonna press play.
Cases giving the court the liberty of looking at all the filings was made in good faith. This is not a question. This is mandated under Florida Supreme Court law. As far as Mr. Shochet, in his memorandum, he attempts to mislead the court on several cases, specifically Mill Pelby v. Kismet, Inc., where he states that the statute of limitations running is an adjudication on the merits. That is completely false. I read all those cases. There's not one case that has said such. What that case did say is exercise of rights to voluntary dismissal terminates the action without prejudice, meaning that the action may be refiled at any time with an applicable statute of limitations. However, costs.
All right, now we have the Komodo dragon eggplant fight. This actually is pretty fun.
In dismissed actions are to be assessed and judgments entered for costs of that action. At no point did it say just because the statute of limitations ran that was an adjudication on the merits for adversely and final ruling from a court. There was no language in any of the cases that he cited. None of my cases, civil cases, were never from a 2019 case. The plaintiff attempts to bring in the federal case that was dismissed after I retired my license, changing my standing, which was the reason that it was dismissed. However, this is a due process issue, as Mr. Shochet never alleged this in his amended motion. Memorandums of law are not meant to amend motions and add new facts. So that was never alleged. Requesting a bond is not right when I haven't even filed a lawsuit. I'm a defendant in this lawsuit. I have not filed one, and this court would have to determine not only that I was vexatious, but they would have to look at the substance of what I filed to see if it had merit or the likelihood of it actually prevailing. Mr. Shochet brings in an audio recording, the partial audio recording of me that's not authenticated. It's not even dated. We have no idea what the full audio was because that wasn't submitted. So I would object on the hearsay. I would object on the rule of completeness. I would object on relevancy. I would object on lack of authentication in considering any of that testimony that he claims that I did. That was not a complete rendition, nor was it even dated. I would ask for all of my exhibits to be entered. They were not objected to, and Mr. Shochet, part of those exhibits, or I'm one of 13 defendants who Mr. Shochet has sued over the last year. 9 of those defendants have been dismissed with prejudice for failure to state a claim against Mr. Shochet and his.
So they're talking about who is the vexatious litigant, and it's not Leslie. It really is a man named Jeremy Hales. This entire motion looks like projection, right? Jeremy Hales is projecting vexatious litigator on Leslie because he's really the vexatious litigator, right? That's what it sounds like to me. I don't know, does it sound like that to the audience? I think Jeremy Hales is the vexatious litigator from his last decade worth of litigation in the state and federal courts of Ohio and Florida and elsewhere. So let's see.
Clients, they have made a habit of, they have 13 people they've sued this year. They go on YouTube, they make content out of it, they harass. And like I said, 9 of his lawsuits weren't dismissed with prejudice. That's an Exhibit A that I entered into my hearing binder if you would like to look at the court recommendation of that. This motion that he brings is done not in good faith, but in bad faith. His clients have harassed me for the last year, defamed me, ruined my teaching job. Just last night went crazy all over YouTube, calling me a vexatious litigant, making fun of my appearance, calling me lips. I have gone through extreme cyberbullying over these people. And he wants to.
So this is, she's detailing the harms. This is, this is pretty bad for Germ. Detailing the fact that he's using litigation for an improper purpose, detailing the fact he's using litigation for polymop, right? Polymop. And the fact of the matter is, maybe this vexatious litigation statute doesn't apply to Jeremy Hales, but it sure as hell, the rules of professional conduct sure as hell apply to Randy Shochet. And I know for a fact that he's got a lot coming down the pike for him, both in litigation in the Northern District of Florida, as well as with the Florida bar, because the pro se statute here for vexatious litigation has an attorney carve out for a reason, right? And that reason is that, if you have an attorney file it, they assume that because they're a member of the bar, they have good judgment on what cases to bring, and the cases aren't frivolous and that have merit. Well, if you can take Jeremy's cases, and everyone's been brought by Randy Shochet, and show that the cases are without merit for improper purposes, for harassment, for different things that don't have any legal basis or factual basis, and are there to do things that aren't proper, the person who's going to be out to dry is going to be Randy Shochet. That's the person to be out to dry. So as far as bad faith is concerned and vexatious, not going to land on Germ. It's going to land on his lawyer, but Germ might have to pay for it. If they sanction monetarily, right, then Germ has to pay those sanctions. If they sanction professionally and refer to the Florida bar, then, Randy Shochet might be taking the long walk. We'll see. All right, what do we got? Let's play some more.
Silence me now so that I have no remedy for help. I have had 4 police reports on this issue. Mr. Shochet has 7 current pending bar complaints from other various people showing his connection with the harassment from these YouTubers. And again, this court, for this court to find me a vexatious litigant under either statute would require me more time. I am prepared. I have given Mr. Shochet a list of 8 witnesses. I am prepared to bring forth all of my filings if this court should believe they have jurisdiction now to go back through old cases that the courts that did have jurisdiction never found such. Mr. Shochet fails to give 5 cases that were finally adversely determined against me, even with the amendment.
But here's Jeremy Hales, because at this point, this motion is dead in my book. DEAD, dead.
Statute. There's not 5 cases that were finally adversely determined against me. I'm allowed to voluntarily dismiss something. I don't like the court, if you wanted, in my opinion, but I have been under a horrendous amount of attack since I retired my license. I have not been happy about it. It's not something I want to do. But at the same point, I go to the police and they say we got to take it up civilly. Again, to consider everything. I don't think that this meets the criteria, and I would ask this court that if before ruling, if this court believes that they need to implement the amended statute, that I'm given a full day hearing to bring in evidence and testimony to prove to this court that
she's asking for a full day hearing. That's not unreasonable given the statute. There's a statutory issue. There's a due process issue. There's what's called ex post facto issue. And that's that. And, John Cook brings up a good point right here. The motion is dead, but Randall doesn't care because he got paid and the haters made the content. That's right. That's 100% right. And that's part of the problem why the vexatious thing has to be laying at the feet of Randall Shochet. There has to be a sanction, and there has to be a pretty hard sanction for this, because they're turning the court into a clown show. It really is. It's this court is a clown show. That's what this is. It wasn't put in for the purposes that it was. When you have a statute and you need certain things, first of all, he's not bringing the same law, right? He's not bringing the same law. It's a different law, so he's not right on the law. If you're a lawyer, if it's tough, I can get it, but it's not tough. The law started on July 1st, 2025, right? And everything that's after that is the new law. Everything that's before it's the old law. But all the stuff he brought was from the old law, but he's trying to apply the new law. But he does this. He didn't do this in the first time he did. He did it. He's doing it against me now in Fed 2 with the Megan Fox breadsticks video. But that's what we got here. That's what we got going on. We got a big problem with Randy Shochet more than anything else. I guarantee you, if Randy Shochet gets taken out of the equation, Jeremy Hales has no content factor. I don't think any lawyer is going to co-opt themselves the same way that Shochet is. This guy's a failed dentist, right? They ran him out of Missouri, and now he's down up in Trenton, Florida, doing insurance cases. And he was a scumbag insurance lawyer for a long time. He still is, and he got yelled at by judges up there. He's just not a good dude, and he doesn't really care. He's old enough where he's going to ride it out into the sunset. What does he care? So I don't know. We'll see. That's the only way I think you get this. But you're right. It is Palomop. This is Palomop. 101 Palomop, and that's what I think it's clear. I think anybody's seen it, it's clear. Let's see. What do we got? You got some questions here. Why wasn't Leslie allowed over? Okay, what happened was they put us on late. And so what happened in the courtroom before that, to my knowledge, is that they tried to argue some legal things. And then the judge was like, no, we're going to I'll deal with that. And they just wanted to get into the hearing. Okay, that's really the only, that was the issue. It wasn't like a trial. That's why she wants the full trial. She's asking for the full trial for that reason, right? Asking for the full reason. And Marla makes a good point. When the other side chooses to give audiences carefully selected snippets so their minions end up watching Richard or Lisa to get the whole story. And that's the truth. Like I'm giving this whole video. I didn't edit it. I didn't pull out the best parts for Leslie. Actually, I did, because the whole video is the best part for Leslie. I hate to say it. Shochet did. I don't think Shochet got any points. If this was a friggin' a football game, it's like fucking 75-0. This is like really, really bad. This is like, no good. This is like one of the worst beatdowns I've seen in a long time. But it is what it is. What does Shochet care? He's getting paid by the hour, paid by the page, paid by the pound. Who fucking knows? But he's getting paid. So that's what it is. So we got this. Let's see. All right.
Nothing I did was done in bad faith. It was always in good faith, and there's no court that ever found me.
Years of cases. She repeatedly filed.
All right. This part is the Randy Shochet rebuttal.
Is clear, Judge.
This is the rebuttal. He comes in and he tries to rehab this at the end. And so this is actually pretty funny to listen to. So think about this. He just got beat up for what, 40 minutes. And now it's garbage time, right? It's like, 2 minutes on the clock. You're down by 50 points. And this is what he comes up with.
Summation. This is summation. This Ferderigos is a person under the statute, not under the 5 or 7 years of cases. She repeatedly files unmeritorious pleadings or engages in tactics, such as we heard today, solely intended to cause unnecessary delay, and that makes her a vexatious litigant under the statute. She's a person, the evidence just shows she's a person who repeatedly files pleadings, requests for relief, or other documents that have been the subject of previous rulings by the court in the federal case, and that makes her a vexatious litigant under the statute. Lastly, Judge, she's a person who repeatedly files unmeritorious pleadings, requests for relief or other documents, conducts unnecessary discovery, and engages in other tactics that are frivolous or solely intended to cause unnecessary delay.
Oh, and here is Doreen Turner-Ankle. Just for everybody, we didn't forget about her. She was in the background before. We're going to bring her to the foreground now. We got this guy over here saying, you cannot be declared a vexatious litigant when you have a lawyer. Vet your shit. That's true. Randy Shochet should have vetted his shit because several of the cases of the 8 that he said, Leslie had a lawyer. So you're 100% right. You cannot be declared a vexatious litigant when you have a lawyer. Vet your shit. Now, you can be called vexatious because that word has a legal and a ordinary language meaning. And Jeremy Hales is a vexatious litigant, though he can't be held under the statute because he's brought everything under an attorney. But Jeremy Hales can be sanctioned, and so can Randy Shochet, and Shochet can face attorney discipline for bad faith activity. And we talked about that before: bad faith and good faith, and bad faith and good faith, right? Meritorious, non-meritorious, right? So when you bring stuff in order to create YouTube content solely with no real reason to bring it other than that, that's bad faith, right? So that's what we got. And that's what we got. So we got these guys. Looks like a Muppet anyway. Look at that. Let's play some more Doreen and Shochet.
In court actions, and that makes her a vexatious litigant under the statute. So, Judge, what we're asking you to do is to declare Ms. Ferderigos a vexatious litigant under the pursuant to Florida statute, section 68.093, enter a pre-filing order prohibiting her from commencing any new pro se action anywhere in this circuit without first obtaining leave of the administrative judge. We also ask that you require her to furnish security in the amount of $37,000 to cover plaintiff's anticipated reasonable litigation expenses.
$37,000. I love it. Because, that's just it. And that brings us back to the story we're talking about. He's asking, he's got no case, he's got no story, he's got nothing else, but he's still going to ask for a crazy amount of money. That's how this guy rolls, Shochet. He's asking for money. I want to see these bills. And actually, I might get a chance to get them. If my case ends up going to if my case ends up going into discovery, I'm going to probably get all the legal bills because it shows his trustworthiness. They're going to fight me over it probably, but I think I get him because it shows he said a different number every other day of what his legal bills are, and it's like crazy. So, who knows? The guy can't tell the truth. He tells either that or he goes on his live and he lies. And that's what he does. He lie. So I don't know. We'll see. Does anybody know how much he's up to yet? What's the last number he said his legal fees are up to? He's asking for $37,000 on this case with Leslie. Every case he thinks that he can go to sue people and make them pay for his legal fees. It's like it's a magician show that he's trying to do. He's out of his friggin' mind. So what is it? Is her diaper showing? Maybe those could be depends right there. Actually, what do we think? Are those depends in the audience? Can you tell me if you think that those are depends? I think they could be depends. They very might well be depends. Doreen is the queen of the briefs and the queen of depends. That's what I hear. The queen of motions and the queen of depends. So let's hear more about Randy trying to cry for money because he's got to pay for Doreen, all her holes and all her depends, I guess. That's what we're going to do.
Including attorney's fees and costs, and grant any other relief, Judge, that you view just and proper. Thank you, Judge.
Thank you both very much. I do have
Now, this is the judge. Well, listen to what the judge is going to do. The judge is going to do what's called reserve decision, right? Reserve decision. And so we'll put that.
To make written findings regarding my ruling on that, and I will do such, so I will take the matter under advisement so that I have enough time to be able to write that ruling out. Thank you both very much. Have a great day.
You too. Thank you, Judge.
Thank you, Your Honor.
You're welcome.
So that's basically the video. That's or the audio. That was the hearing. So, yeah, the Penn's thong. That's pretty funny, actually. But that's what we had here. That's what we had going here today, and that is the video. I don't know. What do people think? We're here. I'll be on for another few minutes, and Lisa's going to be on it in about a half hour with her show. But I'll take a couple minutes here to see what people think about this. If anybody has any questions about this, and address that stuff. But this was a heck of a thing today. It was a heck of a. The hype that you hear out of some people, the hype that you hear is pretty crazy. What do they say? Randall got schooled by Leslie. I think so. I think that's the point, right? I think they got. I think Randy got his ass handed to him. That's really what I heard, right? I think that's kind of what has to happen here is that, and the judge has to make findings. I don't know how this judge can make findings if they're going to do findings of fact and conclusions of law, other than finding for, Leslie Ferderigos not being a vexatious litigant, right? And Helen said that too. Did I miss when the judge told Leslie to shut up? Was that a lie? Well, what happened was in the beginning, Leslie wanted to talk about the law and which statute was applicable, right? When we talked about that, there are two versions of the statute, and she first asked that, and then what happened was she asked that, and the judge says, no, we want to get right into the hearing. And then we come into this hearing because the public got led into the hearing only, after that question or that statement. So that's what I think happened. So, that's where we go. Now, I want to talk about Fed 2 as well, what's left of Fed 2, because everybody knows that this case, the Leslie case, and the other case, the Fed 2 case, have some real good parallels, right? So I want to play something for everybody. And some of you have seen it before, and some of you probably haven't seen it at all. And some of you are aghast by it, and others think it's probably the funniest thing in the world. But this is the core of what's left of the Fed 2 case with Richard Luthmann. This is Jeremy Hales allegedly having sex with a journalist.
I have to fuck her so she obeys me. I don't give a shit about having sex with beautiful women. I fuck them to me so I can get what I actually want, which is not them. It's a means to an end. Every single Bond girl was exploited. That's exactly what I do. When I watch a Bond film and I see him basically pimp a bitch, to me that speaks to my heart. I've been there. I've done that. Anyone who's followed me long enough knows that I've made my $1 million with a webcam business. I have met beautiful women, good personality, and thought she will make me money. I have to fuck this bitch. I don't want to have sex with her. I just need the money.
Won't you take me to Funky Town? Won't you take me to Funky Town? Won't you take me to Funky Town?
What do you have in your mouth? What is that?
So that's the reason why I have to go and deal with Judge Hinkle and Magistrate Bolitho up in the Northern District of Florida. They saying that video is revenge pornography that I have of Jeremy Hales. So that means that, and we'll break that down. I think that means that Jeremy Hales had intimate relations with a journalist. He never identifies a journalist yet, but I heard that journalist likes breadsticks. And that journalist hasn't filed claim against me, not at all. But they're saying that that was somehow a revenge porn situation. I don't see it. And there was a case called The People versus Larry Flint. I don't know if we saw the movie. It was really good with Woody Harrelson and Ed Norton. And if you were to allow something that was satire, and I think that that was satire, I think that everyone will agree that that's satire. But they're going to claim that it's not. And at the end of the day, the same thing with Leslie's case, the same thing with Fed 2, with all the 10 defendants, 11 defendants that got thrown out. The judges, there's a problem with these judges that they're not bringing these people into the courthouse. You see, this case, that video, all the judge has to do is schedule a hearing. 11 o'clock on such and such day, Luthmann and Shochet and Hales and all, we show up at the courthouse, friend of the judge. What's this case about? Judge's case about a video. Well, what's the video? Show me the video. If this was like one of these real no-nonsense judges, they watch the video, they say, what the hell is this in court for? Get the hell out of my courthouse. That was what they would have done early on in Fed 2, right? Instead of having people, especially people who are pro se from across the country, some of them elderly, some of them with sick, relatives. Ray Brunkosh had his wife die, and just make them the court party to that, or the court could be very, common sense. And that's what I think that they're missing there, the common sense, right? And I guess that's the problem here. That's the problem what we have. We're out of common sense with a lot of these people. So really, that's the program that I have. I don't. Let's see if I figured this thing out for Leslie. Leslie wants me to connect this over to her audience. I don't know if I can do that because it allows me to redirect, but I can't see her show on the thing because I think it's members only. So I have no idea. I don't know. So let's see, Tully's. Do I have anything that's coming up for Tully's? No, nothing's coming up for me for Tully's. So I am sorry, Lisa Lee. I don't know. Maybe I'll refresh it and see if that does it for me. But I'm supposed to connect the audience. People probably know what I'm talking about, right? There's a redirect where I can tell everybody you can stay on here and you're going to go directly to the thing. So, but I'll tell you now, because it tells me all the people that I could connect to. And here is it. Who really won today? Two leads in a pod. Oh, I can connect it now. And that's scheduled for today at 10 o'clock. And now everybody's going. Okay, good. So listen, people don't have to go anywhere. This is actually good news. You can stay here now, and you can go to to Leslie's. So we can hang out for another 20 minutes, and I can talk about something else. So let me think about what I want to talk about. What should I talk about the germ? Did I tell everybody about what happened with germ and my YouTube copyrights? That's what we could tell everybody about. That's fun. I can show that. I don't know if Lisa might have shown it on the air, but I can probably show it right now. This is going to be a fun one. Everybody, stay tuned. Let me get it up for everybody because this is what this scumbag did. Jeremy Hales did a YouTube, and I did a pink letter back to him. If you know what the pink letter is the Game of Thrones. I'm a person who kind of likes the good old Game of Thrones. And so I did a pink letter to Holly and Jeremy Adventures, which is Mr. Hales's thing. And I'm going to actually print this so that I could do it the correct way and then put it onto the screen. Let's see, print. So that is going into Leslie. Here we go. All right, now we're going to go to this on the screen. So what he did was he copyrighted me, right, for several videos. And I can show you these videos because I have the back end, and I'll show the videos to people on the back end. But let's see. Let's put everybody back in here. Okay, where am I? I am streaming. And then I am, let's see. Let's remove everything. Remove. And then we're going to present this. This is a share screen. And it is, let's see. Okay. Bear with me. I am the, let's see. Here it is. So this is what I did. And let's see, is this on the screen yet? There we go. Window is that. Share. Okay. Now, everybody's seeing this, right? The pink letter, retract your fraudulent copyright claims, bitch. Right? That's pretty good. That's a good title, right? Do you like that title? I like that title a lot. And so what that title is the title of what I sent him, the letter. It's called the pink letter. And if we know what the pink letter is, that was from the Game of Thrones. That's what the Battle of the Bastards precipitated. And so I said to him, Jeremy Hales, the ignorant bitch, you are commanded to withdraw, retract, and extinguish the copyright removal request you submitted against the following 3 works of journalism: Mother's Day Family Court Firestorm, Cancel Culture Cartel, Dinesh Hales and the Lawyers, Source Hunt, Charity Watch War Room, and the Hales Ecosystem Clown Show. You claim my limited use of excerpts from Busted and Served constituted copyright infringement, right? So actually, let's see if we can get this up there. I'm gonna actually put this one up there. This is the one that they do not like. It's called Busted and Served. Let me see if I can get this queued up for everybody, and we'll see what one is the one they're pissed about. Let's see. Here it is. So I'm going to share this one now with everybody. We're going to switch channels real quick to show everybody what Jeremy's got his panties in a bind about. And it's this one. Pull this down. I'm going to share screen. And we're going to do this one. Aha. Here it is. All right, everybody watch this. Everybody see this one? I'm going to put the volume way up so we can hear. This is an old Jeremy Hales. This is key to this case. This is educational, documentary, scientific, journalistic, artistic. That's all this stuff. Because this is him talking about serving me in this case. And it's an issue in the case. And I'm using this for the limited purpose use to show that he made admissions in my lawsuit. Ready?
He's finally been served after all of his dodging and fake addresses. Dick Luthmann is in another federal case in Florida right now for witness intimidation, defamation, and with the collaboration of their legal team, the plaintiffs, we got him served right there outside of the courthouse. He's in court right now. And when he's on the stand, this is day 2, all he does is plead the fifth or say, no, this is reporter privilege. He won't answer any questions. And yet he's online saying he's going to destroy this other plaintiff and even me.
And that's very true. I am going to destroy Jeremy Hales. Jeremy, you can take that to the fucking bank. I'm going to destroy you. The longer we're in on this, the worse it's going to be. I'm going to fucking destroy you. Okay, let's get back to this.
Remember when Deuce was their savior? And he's destroyed everything. His own credibility, his own business, his own law practice. And he's not out by any stretch of the imagination, even though this anti-team has brought other haters in. The counterclaims are going to be epic. Repeating, known.
Wait. The counterclaims in Fed 2? I thought everybody was dismissed in Fed 2. How does that work, Jeremy? This is going to be so beautiful. Why does this exist? This is totally, fair use, because I'm going to be playing this when I depose you. When I get my videotape deposition of you, asking you the stupid shit that came out of your mouth. How the hell are you going to counterclaim against 9 or 10 or 11 people that were dismissed from your case and you never filed the amended complaint? You're a fucking moron. It just gets better and better. This guy's like human herpes. He's the gift that keeps on giving.
Defamation, rebroadcasting, known. Revenge, prong? Okay, it's an adult activity. You can put the words together with the...
He thinks that that's revenge porn. He's out of his mind. But he's doing it because he's creating Palamop. That's all he's doing. And this actually shows it. This is like a piece of evidence right here. It's actually an evidence in the court. I have other stuff that's evidence in the court. And he tries to do copyrights. When I try to show this to the world, that this is the key to the case, that his case is over, that his credibility is shot, that his claims are bogus, that it's all Palamop, that he should be sanctioned, that Randy Shochet should be sanctioned, that they should be fined, that they should be tagged as people that shouldn't be able to walk into the courthouse. Well, That's where we're going. That's this video is. This is the tip of the iceberg.
Letters. Let's spell it backwards. N-R. Wait, hold a second. I'm not good with letters. As
You're not good with anything, you fucking moron. You're a moron. Show me something you're good at.
we speak, adults are playing a child's game and deleting evidence.
Yes, adults are playing a child's game. We heard that today. Randy Shochet was like a fucking toddler, and Leslie beat him like a redheaded stepchild. That's what happened today. And don't let anybody bullshit you differently.
Information, videos, messages. That's called spoilage. And that, my friends, is illegal.
Spoilage is what happened to your relationship with George. That's what spoilage is, Jerm. Go look it up.
Who's the next to be served in this real-life Garbage Pail Kids story? Well, I could tell you, it's probably going to be a Target. You know, Cheeseland. I love Wisconsin!
He's such a moron. The guy is out there moronic. He really is. He has no clue what he's doing with himself. Really, he's terrible. And then you say service too. The service is the best part because we're going to get on Lisa Lee later, and she's going to talk about how they're trying to serve her with a subpoena, and they're fucking that up too. They didn't even send the G-Man this time. That's the best part. They didn't send the G-Man, right? They didn't send the G-Man this time because you know that guy's credibility is shot to shit. We have him lying 6 ways to Sunday. Okay, so they got to find this new schmuck, and this guy's even worse than the G-Man. I think it was possible. He's worse than the G-Man. All right, let me get back to this thing that I was reading because I get sidetracked. I really did. I get sidetracked with the germ. He gets me, so germy. He's so germy. You claim my limited use of excerpts of busted and served constitute copyright infringement. It's not copyright infringement because that's central to his litigation. He has to understand that he loses copyright infringement protection when he starts making it the central part and material part of his litigation. If he was a content creator, like a normal one that doesn't sue anybody, he'd have all the use of all his copyrights. But the more he goes and does stuff and he does litigation with it, he starts to lose the copyright protection because it goes into fair use. And there's his ugly ass. He's so fucking ugly. Isn't he ugly? He's an ugly, dumb fucker. This is actually a step up for him, I think. We should chain him to a friggin' dungeon someplace so it doesn't cause any problems for anybody else. Okay, here's why. I'm going to tell everybody the law. This is how the law works. And I told this to Jeremy. The experts were used for criticism, commentary, news reporting, documentary analysis, and the exposure of your representations to your audience. We were testing, Jerem, if you tell your audience the truth. That's what that means. The exposure of your representations to your audience, or misrepresentation. You know what a misrepresentation is? If it's an intentional misrepresentation, it's called fraud. If you're lying to your audience, Jerem, it's called fraud. This is not uploaded as substitutes for your program. Nobody wants to watch your shitty program. They were incorporated into independently produced journalistic broadcasts that added narration, context, criticism, and conclusions, and new meaning. Yes, I'm giving my opinion on why you're a fucking idiot, and you're going to lose all your cases. That is fair use under 17 U.S.C. Section 107. You know who I am. I am Richard Luthmann, first of my name, King of the Andals and the First Men, Defender of the Realm, a journalist and a defendant in the federal lawsuit you and Elephant Shoe LLC brought in the Northern District of Florida. You know my reporting concerns, your public conduct, your statements, your media operation, your litigation campaign, and the inconsistency between the stories you sell your audience and the record that follows behind you like a plague cart. And it's the truth. That's a plague cart. It's what it is. It's a dead cart of dead bodies that are dead from the plague, and they throw them into the cart. It's like a frig. That's what it is. It stinks. Busted serves as central evidence in that reporting, without question. You cannot place your own public statements before the world, sue the journalist examining them, and then wield copyright law like a counterfeit royal decree whenever the examination becomes uncomfortable. Copyright is not a gag order, bitch. The DMCA is not your personal headsman. YouTube is not the dungeon beneath your castle, bitch. Your removal requests appear to be another chapter in the same tired Hales verse script. Make the claim, generate the spectacle, punish the critic, and hope nobody examines the underlying record. But this time, your name and email address are attached to a formal legal representation submitted through YouTube's copyright process. Those representations carry consequences. Oh, consequences. A person who knowingly material misrepresents that online material is infringing may face liability under 17 U.S.C. Section 512F, including damages, costs, and attorney's fees caused by the wrongful removal. So those things up there have been down already for a couple of weeks. So I got a claim against you, maybe a counterclaim against you, you fucking moron. Your pending federal litigation against me also makes your motive, knowledge, and communications preservation obligations, right? Spoliation of evidence, you know all about that. If there's one iota evidence that's missing, we play that video and we say, Judge, he knows what spoliation is. We want a presumption, a negative presumption against Jeremy Hales that he destroyed it on purpose. And pattern of conduct fairly subjects the discovery and public reporting. There's Jerm. Right? Look at him. Look at him. He's scared shitless. He's going to shit himself. Who thinks he's going to shit himself? Really? Who thinks this guy's going to shit himself? This guy, I really do think he's going to shit himself. I hope he does, that's what he might do. Jerm, I'm going to give you a free one. Okay? I'm going to give you a free one right now. You should stop doing what you're doing, right? And just shit your pants on YouTube and then just mail them out to people. You do a bidding thing to the highest bidder to send them your shitty underwear. You'd probably make more money than you're making now because you're going to be spending the next, I don't know how long in your life shitting yourself for the stuff that's going to be coming after you, legally and in court. Okay, let's do some more on this. This friggin' ugly bastard. He's so ugly. He really is. Ugh. Winter's coming, bitch. Therefore, here are the terms of this pink letter. Bitch, retract all 3 copyright removal requests immediately. Cause YouTube to restore the 3 videos. Cause the resulting copyright strike against my channel to be removed. Confirm your retractions to me in writing. Now, I will state for the record, there was a copyright strike against my channel and it was removed because I filed the counter DMCA notice and he has 10 business days to show that he's commenced a lawsuit against me under the federal copyright law in the Middle District of Florida. So if he wants to sue me, come sue me. Come, little boy, come and see. Preserve every email, text message, direct message, draft, screenshot, communication, instruction, and consultation concerning these text and communication with Holly Hales because it's Jeremy and Holly Adventures. So I get to, get her into the case. Elephant Shoe, Randy Shochet, Doreen Turner Incolas, any agent or employer, any person involved in identifying or reporting the challenged material. Should you refuse, I will pursue every available remedy through YouTube, the federal courts, appropriate copyright proceedings, discovery, motion practice, public records, investigative reporting, and the merciless tribunal of public ridicule. Yes, Germ, you're a fucking joke and everybody knows it. Your bogus copyright arrows have already been fired. They struck journalism, not infringement. Withdraw them now, bitch. Otherwise, the count of notifications will march. That's already done. The evidence will be preserved. That's already happening. The legal questions will be presented. That's coming. And the Halesverse will once again discover the ancient rule of public combat. He who makes a spectacle of the law should not complain when the spotlight reaches him. And all eyes will be turning to you, sir. Retract the claims, restore the videos, remove the strike. Winter is coming for fraudulent takedowns. And there he is, King Richard, first of his name, King of the Andals and the First Men, protector of the realm, Lord of the Seven Kingdoms, and all the other jazz that comes with it. Be governed accordingly, bitch. So that's what we got going on today with that. I'm amped with that. That was actually a nice little letter. That was sent like last week. It was sent before my vacation. I did a very, very good vacation, actually. I had a lot of fun at my vacation. I did a little bit on my video yesterday on Family Court. I did a Family Court update, and I showed a few of my pictures. But I think we got about 5 minutes to kill. You guys want to see the pictures from my vacation? I'll show you my pictures from my vacation. That wouldn't be a bad idea, actually. Let me do that. I can actually do that now. And then we'll get you guys ready to go over to, you go over to see Lisa Lee, and I guess Robbie will be there tonight, and we'll have a few other people there. I might jump on later. I have to go do some things right now, but maybe I'll jump on in a little bit, and we'll see what's happening. But I had a really, really good vacation, to tell you the truth. It was actually very relaxing vacation. I went up to the Smoky Mountains. And has anybody been to the Smoky Mountains? I really, really like the Smoky Mountains. It was just nice. The Blue Ridge Mountains, the whole thing. We went from the Smokies. We were down in the Blue Ridge portion down in Georgia, too. We went to some places down there with the Helen, Georgia, and some other. It went really, really nice. I went to Dollywood. I love Dollywood. I love Dolly Parton. You know, she's the best, isn't she? Like she's such an icon. She really, really is. But what I've got is, let's see what we've got. I can start showing my my thing right here so people can see. You can see what I did. And let's see. Okay, we're gonna present this. Should share this. Okay, here it is. Here it is. Okay, for everybody to see. All right. So that is Pigeon Forge, Tennessee. Right? It's an awesome spot. A little place called Duck Gear, and they have all the ducks, including, you know, that's a beautiful Trump duck. It's pretty awesome. And then they have the museum, a Hulk Hogan museum. And this is one of the pictures I took with Hulk Hogan. And this was him in Rocky 3, if you remember. Rocky 3, he was Thunder Lips. That was in the very beginning when Stallone came out and they fought for charity. And that was Thunder Lips. And so that was Hogan there. And I actually got a Hogan shirt. I got a couple of Hogan shirts. And they have a full ring in that place where if you want to go in there and you want it to run around, you can actually, you know, pretend you're Hulk Hogan. You can pretend you're a pro wrestler. It's pretty cool. And that's me in the Smokies. See the smoke coming off the mountains? That's really the clouds. That's how they call it, the Smoky Mountains. And here's another one of me in the Smokies. I went right to the edge over there. That's like the cliff, and it goes all the way down. And that's me in the Smokies. And this is me actually in Georgia. You see, I'm not as high. There's no Smoky coming up. This is in the Blue Ridge, and this is actually an orchard behind me. And it's a working, you know, farm, and they had a full cider bar there. And that's when I had a little bit of a cider tasting, which was pretty good. And it was really good cider, the 4 different types. And the second one from the right was really good. That's like a classic cider, and I like that a lot. I think I like that one the most. And then what else do we have? Wait, I missed that one. That's Dollywood. Okay, that's me with my Dolly shirt. And see, I'm sweating through it because went through the whole day and it rained and everything else, but I still love Dolly. And one of the things I love at Dollywood, did I miss a picture there? No, I didn't. Good. One of the things I love is they do fresh cinnamon bread at Dollywood, and I had a bunch of that. It was really, really good, and I had a picture of them making it. They actually make it all day. I went back to the bakery part where they made it, and I was checking that out. I had fun there. There's me at Dollywood, and I walked in, and I had my Trump shirt on. See, Make America Great Again, 47. And then I had to get the Dolly shirt when I got there because it was great. So I had to pick them. This is one of the things I picked up along the way. I went to a German restaurant called the Black Bear Tavern. And they said something that is very, very profound, a very, very profound saying. And that is, in wine there is wisdom, in beer there is strength, and in water there's bacteria. That is an old German proverb. And so that's what I think we went by that one. And let's see, let's show some more. And then I think it's almost getting time for Lisa Lee's show. There's me. That's another day. There's a loop they do in the Smoky Mountain Park. If you ever go to the Smokies, it's really, really fun. I'm telling you. This is down low, and you see the animals, and you can see the mountains from down low. So this is some pictures from there. This is in Anakeesta. This is in Gatlinburg. That's the next town over, Gatlinburg, Tennessee. And you're up, and you take a little cable car up to the top of the mountain. They have a little park, like amusement park up there. It's really, really nice. And then everywhere they have a distillery. So this was a moonshine mule that they made me, and I was drinking this probably at 10 in the morning because everybody else was at the outlet mall. And in the outlet mall, they had the distillery and little tasting room, and so I was doing my tasting very early that day. And see, I got my Buc-ee's hat on. I love Buc-ee's. And then I got the wine and spirits, and this is a menu actually from the Titanic. They have a Titanic there, and you can have the Titanic. You can do the Titanic dinner, and that's what I had. This was the dinner. I think they ate better on the Titanic on April 14th, 1912. But it was a decent meal. It was pretty cool. They had a little show. They had the people there, and then they had cocktails. I had the Edwardian Manhattan when I was there. George Dickel Small Batch Rye, Berto Vermouth, the Torino Rosso, Angostura Bitters, and Luxardo Cherry. It was actually it was very nice. I liked it. Then we saw some elk. That's elk right there. And there's some more elk. And then there's me at Buc-ee's. That's before I shaved. I went a couple of days without shaving. And then this is the picture I put up on the internet. This is for all my haters, right? And all my haters, I'm not dead yet. But, Jeremy, you could look at this one, and you could probably get this poster size and look at it every day to hope that maybe I drop dead, because that's the only way you're going to beat me. Only way on God's green earth that you're going to beat me is if I drop dead. And that's what we got going. Those are my pictures from my vacation. So it's going to be 10 o'clock now. And let's see. I'll put on one more thing because I know Lisa doesn't start on time ever. And so what I'll do is I'll put on the video on the way out of that I was at the Hey Germ that I did when I was on vacation. And that was actually a very nice one. Let me see what we got here. That was the one where I told Germ that he was, where is it? I gotta find it. I don't even know if I can find it. Let's see if I can find it. I did several when I was away, but I think the one that was the funniest one was Rub-a-Dub-Dub. No, it wasn't Rub-a-Dub-Dub. It was Splish Splash. Your opinion is trash. That's what it was. Yeah, I think I can get that one up. Let me get that one up. All right. Let me go to this one. That's this one. Okay, that's what we're going to show everybody. That's what we're going to go out with this. I'll play this for everybody. Splish Splash. Germ's opinion is trash. And then I'm going to let everybody go over and see Lisa Lee's show and have a good time tonight. I think we had a good time tonight. Everybody have a good time with me tonight? I think everybody, a few people did. A few people didn't. I don't think, Germ and his minions had a good time. But I'm going to share that. And this is what we got. You ready?
Hey, Germ. I just wanted to let you know that I'm doing great this summer. I'm actually at Buc-ee's in Kodak, Tennessee. Buc-ee's a great place. I don't think they let you in because I heard about you. But we found a shirt that we may be able to send you because it actually basically tells the truth about you. And here it is. It says, Splish, a splash, your opinion is trash. I think that's the Jeremy Hales story in a nutshell. Splish splash, your opinion is trash. Have a good day, Germ. Ta-ta.
So that is the Splish Splash, Germ. Your opinion is trash. And I will, at that, sign off and tell everybody thank you very much for being here today, looking at the Leslie Ferderigos versus Jeremy Hales case and what happened in court today. Following me is Lisa Lee and two Lees in a pod, Robbie Kesey. I might make an appearance. We'll see. We'll see what happens with me. I may turn into a mushroom or a pumpkin or something. I have no idea. But thank you, everybody, for being here today, and have fun.